So in terms of post-104 IRB entitlement test, suitability has been clearly defined as an important concept from very early on in the case law, going back to 96, probably even before that. And basically it speaks to the kinds of occupations you can put forward as suggesting the client's able to do. So I agree that the question of what is suitable will differ in each case. It may be extremely expansive. It may be restricted to the occupation or employment engaged in at the time of the accident. The evidence will vary according to the facts of each case. The range of suitable employment would encompass that which reasonably flows from the insured's education, training, or experience, and which is neither substantially different in nature, status, or remuneration from the immediate pre-accident employment, nor would require more than a modicum of training or upgrading at the point of time of the injury. So breaking it down further in terms of, this is the arbitrator Seif, the question of suitable employment in every case is a question of fact. The work must be suitable for that applicant, viewed fairly and realistically in the context of his or her educational employment background. Suitable work is not limited to what the applicant was doing at the time. It comes down to previous experience strictly. However, work is not necessarily suitable because an applicant has done a stint of the work in the past. If the job is substantially different in nature, status, or remuneration, may not be appropriate alternative. Okay. In addition, you must consider the time spent in different jobs, the individual's age, his or her qualifications and technical training, as well as know-how. And the primary focus on applicants' functional limitations, wherever job market considerations are relevant in determining suitable employment as well. Okay. So some of the keys that we've seen are, first of all, it has to be an occupation which is suited relative to the person's personal vocational characteristics. It can't be terribly out of line with the type of general work the person was doing before. The issue of socioeconomic status and remuneration are critical. How often have you folks seen a post-104 week IE assessment whereby the person's capacity to earn the same amount of money in the occupations that are being suggested is actually put forward? Do you see them very often saying, okay, well, if the person were one of these three occupations, this would realize this income, and this income compares favorably or poorly relative to what they were earning before? Are you seeing those kinds of, are you seeing those analysis? Are there people seeing them generally?
Well, they do a job survey analysis at the same time.
They might do it, yeah. So they might put forward the earnings applicable to that occupation.
The one job that's available in Ontario.
Right, right. But are they actually making the comparison? They're actually stating?
I've actually had that last.
How often? Out of the past 50 cases you've had?
A lot. There's, on more significant instances, they give a bigger budget to
Okay.
well, they do a market survey, right? Once they consider
Right.
such income, they'll do it in conjunction with their post-104 assessment, right?
Okay, so not so much the labor market survey, but you're actually seeing them say, okay, these occupations would realize incomes of $15,000 to $18,000, and the client before was earning $30,000, and they're drawing that difference of $12,000 to $14,000. Are you actually seeing that? Never seen that. No. I think it's extremely rare from my experience, yet the case law clearly says that even if the person can do these occupations that are put forward, and if there's still a significant earnings shortfall, that is enough to make the entitlement. So they can still actually be collecting an income. But if that income was substantially less than before, they are still entitled to the post-104 week benefit.
They always identify the parking lot tenant.
Absolutely, yes. Yes, very, very commonly. And okay, so somebody, let's say, is a skilled tradesperson before. from the standpoint of their socioeconomic status, how similar is parking lot attendant to that of an electrician or a plumber? Or do you guys consider that to be reasonably comparable socioeconomically? Yes? No? No. So again, on that basis alone, one can recognize a significant shortfall, and therefore the person, in fact, does not meet post-104 entitlement. So these are kind of the fundamental questions that arise from a number of kind of hallmark cases, case law, pertaining to the post-104. These are the kinds of questions that have to be addressed and addressed appropriately in each and every post-104 IE or determination assessment. Is the client substantially unable to perform the essential tasks of the proposed employment? Is the claimant capable of performing employment commensurate in nature, status, remuneration, and hours with the victim's pre-accident employment? So even if they can do what they were doing before, but it ends up being 25 hours per week, that's not sufficient if the person be working full-time in the past. Will the claimant be able to perform the proposed work at a competitive level with the other employees? So you'll see all through IE reports that person took, 15-minute break for every 45 minutes of work they did. I don't know about you guys, but do you know many workplaces where if you have a 15-minute break every 45 minutes, that's acceptable?
Lawyers.
I wasn't going to pick on you guys. But other than the legal profession, we'll say. But you know where I'm going with this. Obviously, that is not considered to be competitively employable if the person's requiring that frequent, that length of breaks. Can the identified occupation be performed with minimal training? Again, how often do you see these occupations put forward in IE reports, whereby to do those occupations, the person will have to go back to community college for a year, 2 years, 3 years? Do you see that? Don't see that so much? Yes, yeah. So is that the equivalent of the person having those skills now and being able to do those jobs now? Well, of course not. But they're making it as if they're equivalencies. The person can do those jobs right here today. Whereas the case law, again, over time, it's generally come to consider a reasonable period of training, if you're going to consider that occupation, as being about 30 days, being about a month. So it's basically enough time for really a training really not training on the job, really an orientation to the job or a brief training on the job in general. Does the recommended work accommodate potential deterioration and avoid promoting deterioration? So if the occupation, even in the medium term, is likely to realize the person becoming overly stressed, anxious, having physical ramifications in terms of likely leading to increased pain over the course of time, you can't consider those occupations. And again, to what extent does the proposed work fit in the pattern of previous work history? This is more controversial in a sense, but in general, they like to see things that where a person who has worked as a laborer, tradesperson, worked with their hands for 25 years, it's not going to be appropriate to put them into an office environment now that they're 50 years old. They've never done anything office-wise, even if they could typically do it. Again, it's a little bit controversial, but it certainly takes it beyond the realm of the person's personal, vocational, historical characteristics anyway. Okay. So, by contrast, the post-104 multidisciplinary rebuttal and or initial post-104 determinations, we always include the following in those for the reasons that I've stated, basically that because we're following what the case law requirements are.